Hello students and my friends, welcome to Disha program. We are powered by Chandra IAS Academy. In Disha program, we are teaching and educating the young minds, the young students of our country about various different things, whether they are national, whether they are international, and whether they are related to the current affairs or the static portion. In this series, today we'll be talking about the Supreme Court's recent verdict on the sub-classification of SCs, that means scheduled castes, and the STs, that means scheduled tribes. All right, so let's see. Okay, first of all, as an introduction, this is the Supreme Court. This is the Supreme Court. So we have already had a lecture on the Supreme Court and the structure of courts in India. Okay, Supreme Court, High Courts, then District Courts. So Supreme Court is the highest court of appeal in India, and it has the power to interpret the constitution. It is the final interpreter of the constitution. So we'll also see how this matter is related to the constitution, article 341. All right, now further let's see. D.Y. Chandrachud, he is the CJI of India, Chief Justice of India, CJI. What is the name? D.Y. Chandrachud. So he headed the bench of the 7 judges. A bench mean a group of judges judging on some matter. Okay, so which gave the verdict in a 6:1. 6 means they favored this verdict, and one of the judges said, "No, I do not agree to this verdict." Okay, so this verdict was passed. Now, what is the verdict? That a subcategorization in the quota, reservation quota given to the SCs and STs can take place. Okay, that means further categorization of the scheduled caste and the scheduled tribe can take place. All right. And who these quota will be given to? To whom these quota will be given? To the most backward classes, even among the SC and the ST. All right. Now let us see what are these SC and ST. So in the Hindu classification system, in the Hindu caste system or the Varna system, historically, the classes were divided into 4 parts, such as the Brahmins, the Kshatriya, the Vaishya, and the Shudra, and the Dalits. Alright, now these Shudra as well as the Dalits often come in the SC. In the British period, they were started to know as the depressed classes. The depressed classes. Because they were socio-economically, not only socially, but also economically backwards. The works that they were allotted, their occupations, they were understood to be unpure or of polluting nature, such as the cleaners, the unskilled workers, the servants, or those who deal with the dead bodies, or so on. All right, those who deal with the animal waste, human waste. Second thing, we come about the tribes. That who are the tribes? So these were at least a social part. The SCs were at least the depressed classes who were integrated into the society. However, when we come about the ST, that means tribes. So these tribes were the classes or the populations that lived outside of the cities completely, mostly in the forests, had their own customs, cultures, languages, rituals. Alright, so these were known as tribes or Vanvasi. Vanvasi. Or also known as Adivasi. Alright, so these are the SCs and STs. Now what we see further, these are the SCs. Okay, so they have a considerable population in the India and they are constitutionally recognized. Constitutionally recognized. Second thing, when we talk about the ST in a similar manner, you can see the percentage of the scheduled tribes by the 2011 census and so on. So the northeastern area and the, let's say, Ladakh area, they have the most ST population. All right, these are also known as the tribals of India. Now, because of their social and economical backwardness, they were given reservation in the government jobs and the quotas and so on by the Mandal Commission and further on. Okay, since 1950s. Since 1950s. So now we need to see what has changed. What has changed? What is the change now? And what is the history here? Okay, so let's see this. So there was a judgment. There was a earlier judgment in 2004 in Andhra Pradesh. So what was the case name? The case name was E.V. Chinnaiya. E.V. Chinnaiya versus the state of Andhra Pradesh. Versus the state of Andhra Pradesh. So in which the High Court of the Andhra Pradesh held that the SC and the ST, they are a homogeneous group. They are a homogeneous group. Homogeneous means they do not have internal differences and all of the SC and ST are equally socio-economically divided. Okay, but now the Supreme Court has recognized that this is not the case. Even among the SC and ST, some people are socio-economically higher and some people, some population is socio-economically quite low. They have internal differences, sub-classifications also. All right, so this is why Supreme Court has said that they can be given reservation and quotas according to their sub-classifications. Okay, next thing is Constitution. What does the Constitution say in this regard? Okay, so this we need to see. What is the constitutional aspect? Okay, so let's talk about this. Article 341. Article 341 of the Indian Constitution allows the president, please remember, allows the president, not the prime minister, not the chief minister of a state, not the governor of a state. It allows the president of the country, that is India, to declare, okay, to declare any caste as SC or ST. Okay, usually these notifications come with the agreement of the respective states. Okay, next thing is, what is the modernist view? What is the modernist view of the Supreme Court? Okay, so the modern view of the Supreme Court. So Supreme Court has said, just a second. Okay, so Supreme Court has said that SC is a legal fiction. The category is a legal fiction. That means we have assumed wrongly that SC is a homogeneous group. It has internal differences and that is why subclassification has to be allowed between them. Alright, so one more thing we need to see, that has there been any previous cases or previous attempts? So yes, in 1975, Punjab given some extra reservation or first preference to two communities in the SC, among the SC, which are Balmiki and Mazhabi Sikh. Mazhabi Sikh community. So this was challenged in 2004 with the court's decision, which I told you already, which was the decision in the Andhra Pradesh, E.V. Chinnaiya. E.V. Chinnaiya. So in this Andhra Pradesh state held that SC is a homogeneous group and this preference is also invalid. Alright, so this now has turned into a milestone decision in 2024. These all decisions are, let's say, invalid. Even this decision is invalid and overturned, and subcategorization is possible. Okay, so this is a good step for SCs, the backwards, most backward communities in the SC, and I hope that they will be taking benefit of this and given, let's say, more socio-economic equality. All right, thank you very much. So this lecture will end here. If you have any comments, any feedback, you can let me know in the comment section. Have a great day ahead and see you soon.